So good morning, ma'am. Good morning, my classmate. So my topic today is about the community and its role and responses to children in conflict with the law. So let's start. So for the introduction, let's define first what is the children in conflict with the law. So the term children in conflict with the law refers to anyone under 18 who comes into contact with the justice system as a result of being suspected or accused of committing an offense. Most children in conflict with the law have committed petty crimes or such minor offenses as vagrancy, truancy, begging, or alcohol use. So some of these are known as status offenses and are not considered criminal when committed by adults. So in addition, some children who engage in criminal behavior have been used or coerced by adults. So to often prejudice related to race, ethnicity, or social and economic status may bring a child into conflict with the law even when the crime has been committed or result in harsh treatment by law enforcement officials. So all children in conflict with the law in the Philippines are afforded appropriate protection measure as provided for by the United Nations Convention on the Rights of Children. So in other relevant international instruments on juvenile justice that will promote their dignity and worth as persons and become active participants of social change. So in the Philippines, members of Congress have passed bills intended to make laws more consistent with the Philippines' advocacy on juvenile justice. As much as the Philippines should be concerned with the juvenile justice system in harmony with international policies, the dominant goal is to achieve a standard national policy on CICL. So rather than an accurate reproduction of an international model on CICL. So what is RA 9344? So in RA 9344, this is a one bill passed into law institutionalize the promotion of the well-being of child and their families, involvement of parents and guardians. So promotion of diversion, avoiding deprivation of liberty, and protecting the privacy rights of children. So what is RA number 10630? So this is further emphasize child sensitive justice policies. So focus on the best interest of the child. So this principle has been first laid down in the Doha Declaration. So the main features of RA 9344 are the diversion and intervention program. So during the diversion process, the responsibility and treatment of CICL will be determined in the basis of his or her social, cultural, economic, psychological, or educational background without resorting to formal court proceedings. So if the CICL is found to be responsible for an offense, he or she will be required to undergo diversion programs without resorting to formal court proceedings. So during the intervention program, on the other hand, they will undergo a series of activities to address issues that cause them to commit an offense. So this may take the form of counseling, so skills training, and education. So the bigger the role these diversion and intervention programs play in child behavior development, so the more acceptance and social legitimacy these programs are likely to enjoy in resolving problems with the CICL. So in RA 9344 also likewise raises the age of criminal responsibility from 9 years of age under Presidential Decree 603 to a minimum of 15 years old. CICL age 15 and above are also exempted from criminal liability unless the prosecution proves that they acted with discernment. So the capacity to distinguish right from wrong. So, sino ba ang pwedeng gumawa nito? So, based on my experience, always ang nagkakandak ng discernment nito ay ang DSWD. So, nagkakandak sila ng some examination para malaman or ma-distinguish nila kung ang isang CICL is know what is the right from wrong. So, these child offenders are also afforded all the rights of a CICL until he or she is proven to be 18 years old or older than the presumption of minority rule. So, in all proceedings, law enforcement officers, prosecutors, judges, and other government officials concerned are mandated to exert all efforts at determining the age of the CICL. So, Republic Act number 10630 or the Act strengthening the juvenile justice system provided for the establishment of an intensive juvenile intervention and support for children under the minimum age of criminal responsibility in Bahay Pag-asa. So, ano ba yung Bahay Pag-asa? So, the Bahay Pag-asa is a 24-hour child care institution funded and managed by local government units or LGU and licensed or accredited non-government organizations. So, children in conflict with the law who are 15 to 18 years old shall be housed in these temporary shelters while awaiting trial, the judgment to be rendered by the court. So, ilalagay sila sa Bahay Pag-asa as their shelter or temporary shelter habang hinihintay nila yung proceedings or yung trial na habang or dinidinig yung kanilang kaso. Yes. So, the law also clarified procedures for children below the minimum age if criminal responsibility or including those who commit serious offenses. So, it provides that any child aged 12 to 15 who commit a serious offense punishable by more than 12 years imprisonment should be deemed a neglected child under the Child and Youth Welfare Code. As a neglected child, so the minor should be placed in the IGISC. So, the same is true with a child who was previously subjected to a community-based intervention program. So, he shall also be deemed a neglected child and as such shall undergo an intensive intervention program supervised by the LSWD or DSWD. So, the child will undergo appropriate intervention program through the written authorization for voluntary commitment of the child as executed by the parents or guardians or through a petition in the court for the involuntary confinement filed by the LSWD or DSWD. So, the Bahay Pag-asa will be managed by a multidisciplinary team composed of a social worker, a psychologist or mental health professional, a medical doctor, an educational guidance counselor, and a member of the Barangay Council for the Protection of Children or BCPC. So, they will come up with individualized intervention plan for the child and her family. So, based on the recommendation of the multidisciplinary team of the IGJISC, the LSWD or the DSWD, the court may require the parents of the CICL to undergo counseling or any other intervention that would advance the best interest of the child. So, one of the disposition measures that can be availed of by a CICL under suspended sentence is community-based rehabilitation. So, wherein he or she shall be released to parents, guardians, relatives, or any other responsible person in the community. So, the LSWDO shall supervise the CICL in coordination with or her parents or guardians. So, example of these programs are competency and life skills development, socio-cultural and recreational activities, so community, volunteer projects, leadership training, spiritual enrichment, and family welfare services. So, a child under the minimum age of criminal responsibility shall also be subjected to a community-based intervention program supervised by the LSWDO. So if the best interest of the child requires, so the CICL shall be referred to a youth care facility or Bahay Pag-asa managed by the LGU or licensed and or accredited NGOs monitored by the DSWD. So as mentioned previously, a CICL was previously subjected to a community-based intervention program can be deemed a neglected children or child. As such, he or she shall undergo an intensive intervention program supervised by the LSWDO or the DSWD. So, aftercare support services shall be made to prevent reoffending. This will be given for a period of at least 6 months. So these services could include life skills development, livelihood programs, and membership to existing youth organizations. So the aftercare support services shall be provided by the LSWDO. However, licensed and accredited non-government organization may also be tapped. So as with the previous program, it will require active participation of both the child and her parents or guardians. The ultimate objective of providing the children in conflict with the law with intervention that will improve their social functioning is for them to be eventually reintegrated to their families and to their communities as well. So in general, this is the objectives of the study. So in general, the study aims to establish the role and response of the community in children in conflict with the law. So within the context of the criminal justice system, so specifically to the following. So the conduct of diversion proceedings where the parties agrees to a settlement that benefits the CICL, the victim, and the community as well. So the development and implementation of diversion program that will not punish but rehabilitate and modify the CICL's behavior. So enhance parental skills as well as increase community awareness, thereby prevent reoffending as well as facilitate healing and sense of justice for the victim. So supervision and monitoring of compliance to diversion contract and role and response of the community to CICL. Actually, this is the role of the community in CICL. So, yeah, okay. Let's know the literature study. Bakit ba nagkakaroon ng ganitong behavior yung isang young people, no? Bakit nagbabago or nagbabago yung mga behavior nila or nakaka-commit at nai-involve sila sa mga illegal activities or crime. So, let us know. Society's concerns for children is very evident in the large collections of literature on their situation, issues and concerns and development. So, however, literature that specifically delves in the intricacies of the situation of CICL is very limited. Ayan. So, who are the children in conflict with the law? Like what I've said before. So, various researches and surveys national in scope have established trends in the profile of juveniles according to existing studies. So CICL are usually males between the age of 14 and 17 who have low educational attainment. So mostly reaching only the elementary level. They are usually middle or in between children in very large low income families. So various studies have established that many of these children are either on the street or of the streets when they were apprehended, while a significant number still live with parents or relative. They are usually out on the street to take out a living or are involved in peer groups or gang, so which are usually associated with vices and illegal activities. So karamihan daw ng mga juveniles, no, mga CICL natin ay between age of 14 to 17 who have low educational attainment or yung mga walang pinag-aralan. So mostly reaching only the elementary level only, no, yun lamang yung kanilang natapos. So karamihan sa kanila ay usually is a middle or in between children in very large low income families. Ibig sabihin, yung mga nabibilang sa mga poorest family. Ayan. So, in the area of juvenile justice, so UNICEF aims to reduce incarceration while protecting children from violence, abuse, and exploitations. It promotes rehabilitation that involves family and communities as a safer, more appropriate, and effective approach than punitive measures. So, justice system designated for adults often lack the capacity to adequately address these issues and are more likely to harm than improve a child's chances for reintegration into society. So for all these reasons, so UNICEF strongly advocates diversion or directing children away from judicial proceedings and towards community solutions or restorative justice, which means promoting reconciliation, restitution, and responsibility through the involvement of the child, family members, victims, and the communities, and alternatives to custodial sentencing. So, which is counseling, provision, and community service. Minsan kasi, ginagawa nating alternative para hindi siya makulong, or ginagawa na lang natin na kina-counseling, merong provision, ina-allow natin yung provision, and the community service. Depende sa na-commit na crime ng isang CICL. So, facts and figures. So, more than 1 million children worldwide are detained by law enforcement officials. So, in many prisons, institutions, children and young persons are often denied the right to medical care, education, and individual development. So, in 2002, 136,000 children in the CEE or CIS region were sentenced for criminal activities compared to 117 in 1990. So, Russia alone accounted for 65% of these numbers. The topic of juvenile delinquency is a fertile area for construction of sociological theory. So, we have three major sociological traditions, including structural functionalism, symbolic interactionism, and conflict theory, contribute to the explanation of delinquency. So, ito yung mga theory na merong explanation bakit merong delinquency, or yung pagbabago sa mga behavior of the young people. So, much of the work in this area seeks to explain why officially recorded delinquency is concentrated in the lower class or in what is today more often called the underclass. So, this entry considers the most prominent theories of delinquent under the theoretical rubrics noted above. So, first is structural functionalism and delinquency. So, structural functional theories regard delinquent behavior as the consequence of strains or breakdowns in the social processes that produce conformity. These theories focus on institutions such as the family and school that socialize individuals to conform their behavior to values of the surrounding society on the way in which this institution can fail in this task. So, wide agreement or consensus is assumed about which behaviors are valued and disvalued in society. So, the question structural functional theories try to answer is, why do many individuals during their adolescence behave in ways that challenge this consensus? So, that is, why do many adolescents violate behavioral norms that nearly all of us are assumed to hold in common? So, anomy theory. So, what is the anomy theory naman? So, according to the anomy theory, the roots of functional theory are found in Durkheim's notion of anomy on 1897 to 1951. So, the Durkheim, this term meant an absence of social regulation or normlessness. So, according to Merton, noong 1938 to 1957, revived the concept to describe the consequences of a faulty relationship between the goals and the legitimate means of attaining them. So Merton emphasized the features of social and cultural structures, culturally defined goals such as monetary success and the acceptable means such as education to their achievement. That Merton argued that in our society, success goals are widely shared, while the means of opportunities for attaining them are not. So according to the Merton's theory, is used to explain not only why individual adolescents become delinquent, but also why some classes are characterized by more delinquency than others. So since members of the lower or underclass are assumed to be most affected by the disparity between the goals and the means of attaining success, this class is expected to have a higher rate of delinquent behavior. So Merton outlined a number of ways individuals adapt when faced with inadequate means of attaining their goals. Among these, innovation revolves substituting illegitimate for legitimate means to goal attainment. So it is the resort to this adaptation that is true to account for much theft among adolescents from the underclass. Next, subcultural theory. So according to subcultural theory, group-based adaptation to the failure to attain success goals involve the delinquent subculture. So Cohen on 1955 suggests that children of the underclass and potential members of a delinquent subculture first experience a failure to achieve when they enter school. So when assessed against a middle class measuring rod, these children are often found lacking. A result is a growing sense of status frustration. So underclass children are simply not prepared by their earliest experiences to satisfy middle class expectations. So the delinquent subculture therefore emerge as an alternative set of criteria or values that underclass adolescents can meet. Ayan. So, Cohen argues that these subcultural values represent a complete refutation of middle class standards. So the delinquent subculture express contempt for a middle class lifestyle by making its opposite a criterion of prestige. So the results, according to Cohen, is a delinquent subculture that is non-utilitarian, malicious, and negativistic. So an inversion of middle class values. Yet, this is only one possible type of subcultural reaction to the frustration of failure. So as we see next, many subcultural responses are elaborated in the theoretical tradition of structural functionalism. So differential opportunity theory. According to Cloward and Olin on 1960, they argued that to understand the different forms that delinquent and ultimately criminal behavior can take, we must consider the different types of illegitimate opportunities available to those who seek a way out of the underclass and where these opportunities lead. So different types of community settings produce different subculture responses. Cloward and Olin suggest that three types of responses predominate, each one leading to its own respective subculture. So, a stable criminal subculture, a conflict subculture, and retreatist subculture. So, the stable criminal subculture offers, as its name suggests, the most promising prospect for upward economic mobility. So, according to Cloward and Olin, this subculture can emerge only when there is some coordination between those in legitimate and in illegitimate roles. For example, between politician or police and the underworld. So, one pictures the old-style political machine with protection provided for prepared types of illegal enterprise. So only in such circumstances can stable patterns be established, allowing opportunities or advancement from adolescent to adult levels of the criminal underworld. So when legitimate and illegitimate opportunity structure are linked in this way, the streets become safe for crime, and reliable upward mobility routes can emerge for aspiring criminals. So violence and conflict, in the other hand, disrupt both legitimate and illegitimate enterprise. When both types of enterprises coexist, violence is restrained. However, in the disorganized slum, where these spheres of activity are not linked, so violence can reign uncontrolled, because according to Cloward and Olin, see these types of communities as producing a conflict subculture. So a result of this disorganization is the prevalence of adolescent street gangs and their violence activities, making the street unsafe for more profitable crime. So the retreatist subculture includes adolescents who fail in their efforts in both the legitimate and illegitimate opportunity structures. These double failures are destined for drug abuse and other forms of escape. So, Cloward and Olin's jury played a role in encouraging the Kennedy and Johnson administration of the 1960s to organize the American War on Poverty, so which attempted to open up legitimate opportunities for youth and minorities in the underclass. However, another important variant of structural functional theory argued that the most important cause of delinquency was not a strain between goals and means, but rather a relative absence of goals, values, commitment, and other sources of social control. So, social disorganization theory. So, the earliest North American efforts to explain crime and delinquent in terms of social control focus on the absence of social bonds at the community level. So, entire neighborhoods were seen as being socially disorganized, as lacking the cohesion and constraint that could prevent crime and delinquency. So this work began in the late 1920s. So when Clifford Shaw and Henry Mackay 1931 to 1942 sought to identify areas of Chicago that were experiencing social disorganization. So they explored the process that characterized these communities that they found were indication of what they assumed to be social disorganization. So truancy, tuberculosis, infant mortality, mental disorder, economic dependency, adult crime, and juvenile delinquency. So, yan yung mga some activities, illegal activities. So, in Chicago, the rates of this condition were highest in the slums near the city center. So, they diminished in areas farther away from the center. Since these problems were assumed to be contrary to the shared values of area inhabitants, so they were taken as indication that these areas were unable to realize the goals of their residents. In other words, they were taken as indicator of social disorganization. So, Shaw and Mackay also attempted to determine the sorts of community characteristics that were correlated with delinquency, so that they could infer from these characteristics what the central components of social disorganization were and how they cause delinquency. So, three types of correlates were identified: the economic status of the community, the mobility of community residents, and community heterogeneity. So, the implication was that poverty, high residential mobility, and the ethnic heterogeneity so lead to a weakening of social bonds or controls and turn to high rates of delinquency. So all of this was being said of the neighborhood Shaw and Mackay studied. It was left to later juries to spell out the meaning of weakened neighborhood bonds or controls for individuals. Yeah. So control theory. In control theory, at the level of individuals to have neighbor goals, norms is to uncommitted and this uncontrolled. Hershey noong 1969 has argued that the absence of control is all that reality is required to explain much delinquent behavior. So there are other types of control besides commitment to conformity that may also operate involvement in school in other activities. So attachment to friends, schools, and families, and belief in various types of values and principles. So Hershey argued that delinquent behavior is inversely related to the presence of this control. So alternatively, as this control accumulate, so to does conformity. According to control theory, the more committed, attached, involved in believing individuals are, the greater is their bond to society. So again, Hersh's chief point is that no special strain between goals and means is necessarily required to produce delinquent behavior. All that is required is the elimination of the constraining elements of the social bond. Ayan. So, despite the richness of sociological theories of delinquency and the emerging sense of the convergence among previously competing theoretical traditions, so there is a new awareness that delinquency theories remain incomplete in their capacity to explain and sometimes even addresses basic micro and macro level questions. For example, a classic issue that persists despite its recognition is the question of why most delinquents discontinue their delinquency before or during their transition to adulthood. Or we know that most delinquents age out of delinquency, but we have not adequately explained why this happened. So Hershey and Gottfredson on 1983, according that to them. So our theories are much more attentive to why young people become delinquent than to why they stop being so. So in each of the theories that we have considered, thus far values of beliefs, this belief plays some role in causing delinquency. So it is argued that the presence of success, goals, or values without the means to obtain them can produce deviant behavior, as can the absence of these goals or values in the first place. It is emphasis on these values and the role of the school and family in transmitting them that ties the structural, functional theories together. In discussion, let's discuss role and response. So, what is the role and responses of the community to children and conflict with the law? So, ito talaga yung pinaka-main topic natin dito. So, ano ba yung pwede natin gawin as being response natin or yung role natin being a community or being nasa community or involved tayo sa community to children and conflict with the law? First is building a protective environment for children. So, government commitment and capacity. So these are crucial to promote and support policies that encourage the use of alternatives to deprivation of liberty. So a proper approach to juvenile justice also requires that efforts be made to prevent children from coming into conflict with the law in the first place. So this is work for the entire society, not just the government. So, legislation and enforcement. So, national law should be revised to conform with international standards. So, with legislation enacted and enforced to prevent children from being deprived of their liberty when they have been victims of abuse and exploitation, were used by adults for criminal activities, or have committed status offenses or petty crimes. So, the death penalty for children should be abolished. Ayan. Attitude, costume, and practice. So, children in conflict with the law may be portrayed as a wicked or threatening, and presumption of character need to be challenged. So, the establishment of appropriate juvenile justice mechanism can be difficult of public opinion, favors tougher responses, and harsher sentences. So, open discussion, the media can promote appropriate approaches to children in conflict with the law, including provision and community service. So, objective and responsible reporting of crimes committed by children and the abuses they face in contact with the law can increase public support for juvenile justice. So, children's life skills, knowledge, and participation. So, ano naman ang role nito? So, children who come in conflict with the law need to be informed about their rights. So, preventive measures can improve children's understanding of their responsibility under the law and help them avoid conflict. So, capacity of families and communities. So, capacities need to be strengthened to enable community involvement in the process of restorative justice. So, law enforcement officials should be familiar with constructive approach that make it possible to avoid formal arrest and detention of children in conflict with the law. So, the capacity and knowledge of juvenile judges, magistrates, social workers, and police need to be strengthened, no? Kailangan palakasin and increase in the area of juvenile justice. So, kailangan alam din nila how to handle the CICL. Essential services including for prevention, recovery, and reintegration services should be in place, offering community-based and family-focused assistance so that children can achieve rehabilitation and avoid repeat offenses. So, monitoring, reporting, and oversight. So, these are needed to determine the number of children in detention, the proportion of those awaiting trial, and trends in sentencing. So, monitor can ensure that detention is neither illegal nor arbitrary, so that children have access to all basic social services and that they are not detained alongside adult prisoners and exposed to violence and abuse. So, at the global level, so UNICEF is a member of the Interagency Panel, no, on Juvenile Justice, which aims to enhance national and global coordination in juvenile justice, so including by promoting ongoing dialogue with national partners in juvenile justice reform and identifying, so developing and disseminating common tools and good practice. So, in the Republic of Moldova, UNICEF supported the government in the developing the new criminal law and the criminal procedure code, which provide for improved juvenile justice and bring local legislation in line with the standards of the Convention of the Rights of the Child. So, in Panama, so the UNICEF provide journalists with data and children in conflict with the law in order to help dispel myths and exaggeration of adolescent crime. So, UNICEF also facilitated training courses in the Convention on the Rights of the Child, which built capacity among journalists to report on the rights of children in conflict with the law. So, in the Philippines, so the Philippines treatment of CICL, so treatment of children below the age of criminal responsibility, if it has been determined that the child taken into custody is 15 years old or below. So, the authority which will have an initial contact with the child in coordination with the local social welfare development officer or LSWDO has the duty to immediately release the child to the custody of her parents or guardian, or in the absence thereof to the child nearest relative. So, if they cannot be located or they refuse to take custody of the child of the CICL, or the CICL may be released to any the following. So, a duly registered non-governmental or religious organization, a barangay official, or a member of the barangay council for the protection of children, or the Department of Social Welfare and Development. So, authorities Authorities which have initial contact with the child refer to law enforcement officers or private citizens apprehending or taking custody of the CICL. So if the LSWD determines that the child is abandoned, so neglected or abused by his parent, or in the best interest of the child, requires that he or she be placed in a youth care facility or Bahay Pag-asa. So the child parents or guardian shall be executed written authorization for the voluntary commitment of the child. So but if there are no parents or guardians, or they will not execute it, so the DSWD shall file the proper petition for involuntary commitment. Only those who are at least 12 years old can be committed to a youth care facility. Ayan. So, treatment of CICL depending on whether they acted with or without discernment. So, paano naman? Yung response natin diyan. So, the social worker using the discernment assessment tools developed by the DSWD will come up with an initial assessment which is without prejudice to the preparation of more comprehensive case study report. So the local social worker can either release or commit the child to youth care facility if he or she is 15 years old, or 15 years or below, or above 15 but below 18 years old, but who acted without discernment. However, if the child is above 15 years old but below 18 and who acted with discernment, so diversion should be implemented. So, system of diversion. If the imposable penalty for the crime is not more than 6 years imprisonment, mediation, family conferencing, and conciliation, or other indigenous modes of conflict resolution in consonance with restorative justice, shall be facilitated by the law enforcement officer or punong barangay with the assistance of the LSWD. or members of the BCPC. So, both the child and her family shall be present in these activities. So, in victimless crime, where the imposable penalty is not more than 6 years imprisonment, so the LSWDO shall develop an appropriate diversion and rehabilitation program in coordination with the BCPC. Again, involvement of the child in her parents or guardian is a must. So, kailangan laging naka-involve ang parents or guardian ng isang CICL. So, where the imposable penalty for the crime committed exceeds 6 years imprisonment, so diversion measure will be decided by the court. So, the diversion program shall cover socio-cultural and psychological services for the child, which may include reparation of the damage caused, counseling, participation in available community-based program, or in education, vocation, and life skills program. So, at the all level of the appropriate core, in addition to the program cited, so diversion program can also include reprimand, fine, or institutional care and custody. So, a diversion program will depend on the individual characteristic and the peculiar circumstances of the CICL. Some of these factors are the child's feeling of remorse, the ability of parents or the guardians to supervise, the victim's view, and the availability of community-based programs for rehabilitation and reintegration of the child. So, in case of failures to comply with the terms of condition of the contract of diversion as certified by the LSWD, so the offended party can institute the appropriate legal action. Also, if no diversion took place because the imposable penalty exceeds 6 years, or the child or her parents does not consent to diversion, so the case shall be filed according to the regular processes. Next is release and recognizance. So, ano ba ang release and recognizance? So, where a child is detained, so the court shall order the release of the minor on bail or release on recognizance to her or to his parents and other suitable persons. So, the court has also the option to transfer the minor to a youth care facility. In no case shall the court order the detention of a child in a jail pending trial or hearing of his or her case. Ayan. So, What is discharge? Ano naman yung discharge of child in conflict with the law? Kapag na-discharge na yung CICL, ano naman yung gagawin? No? When at the time of the commission of the offense, the child is under 18 years old and subsequently is found guilty of the offense, no? Charge, the court shall be placed the CICL under suspended sentence without need of application. So the suspension of sentence shall still be applied even if he or she is more than 18 years at the time of the pronouncement of his or her guilt. So pwedeng masuspended yung sentence kahit pa na siya ay napatunayan na siya ay guilty dun sa kasalanang ginawa niya. So, the court shall impose the appropriate disposition measures in consideration of the various circumstances of the CICL. So, upon recommendation of the social worker who has custody of the child, so, the court shall dismiss the case if it finds that the objectives of the disposition measures have been fulfilled. Ayan. So, confinement of convicted children in agricultural camps and training facilities. So, after conviction, and upon order of the court to serve his/her sentence, a CICL may, in lieu of confinement in regular penal institution, serve as an agricultural camp in other training facilities that may be supervised by the Bureau of Correction in coordination with the DSWD. So, the competent authority, this is the family courts, have exclusive jurisdiction over cases involving children in conflict with the law. So, jurisdiction is vested with regional trial courts in places where there are no family courts. So, the Philippine Institutional Treatment of CICL. So, according to the Public Act number 10630 or the Act strengthening the juvenile justice system, provided for the establishment of intensive juvenile intervention and support center for children under the minimum age of criminal responsibility in Bahay Pag-asa. So, the Bahay Pag-asa is 24-hour child care institution funded and managed by local government units, LGU, licensed or accredited non-government organization. So, children in conflict with the law who are 15-18 years old shall be housed in this temporary shelter. So, gaya po ng discuss ko kanina, so yung Bahay Pag-asa ang pwedeng dalhin doon yung mga bata na habang dinidinig yung kanilang kaso, no? As their temporary shelter. So, the law also clarified procedure for children below the minimum age of criminal responsibility, including those who commit serious offense. It provides that any child aged 12 to 15 who commits serious offense punishable by more than 12 years imprisonment should be deemed as a neglected child under the Child and Youth Welfare Code. So, as a neglected child, the minor should be placed in the IGISC. So, the same is true with a child who was previously subjected to community-based intervention program. He shall also be deemed a neglected child and as such shall undergo intensive intervention program supervised by the LSWD. So, the child will undergo appropriate intervention programs through the written authorization for voluntary commitment of the child as executed by the parents or guardians or through a petition and the court for the involuntary confinement filed by the DSWD. Yeah. So, the Bahay Pag-asa will be, parang bumalik po ako. Ayan. So, the Philippine Community-Based Non-Institutional Treatment of CICL. So, who can avail? No? So, one of the disposition measures that can be availed by the CICL under the suspended sentence is community-based rehabilitation, wherein he or she shall be released to parents, guardians, or relatives, or any other responsible person in the community. So, the LSWDO shall supervise the CICL in coordination with his or her parents or guardians. So, example of these programs are competency and life skills development, socio-cultural and recreational activities, community, volunteer projects, leadership and training, spiritual enrichment, and family welfare services. So, a child under the minimum age of criminal responsibility shall also be subjected to a community-based intervention program supervised by the LSWD. So, in cooperation between community-based treatment and institutional treatment, if the best interest of the child requires, the CICL shall be referred to Youth Care Facility or Bahay Pag-asa managed by the LGU or licensed accredited NGO monitored by the DSWD. So as I mentioned previously, a CICL who was previously subjected to community-based intervention program can be deemed a neglected child. So as such, he shall undergo an intensive intervention program supervised by the LSWD. Ayan. So, as our conclusion, so community programs are provided by many different individual. So, organization, each with their own unique approach and programmatic activities. So, they may be provided by a local affiliates of large national youth serving organization or maybe an independent organization that is affiliated with a public institution such as a school or public library. So, they also may be a small autonomous grassroots organization that exists independently in a community. So, the focus of the activities may be sports and recreation, faith-based lesson or faith-based lessons, music and dance. So, academic enrichment or workforce preparation. Programs may be also targeted only to girls or only to boys. So, to a particular ethnic or religious group or to a young people with special interests. In addition, programs differ in their objectives. So, and many may choose to give more emphasis to particular program features. So, community-wide organizing of youth policies as well as support for individual programs also varies from community to community. Where there is a community infrastructure for support, the organizing body in a community might be the mayor's office, a local government agency, or community foundation. It might be a private intermediary organization or an individual charismatic leader, such as a minister or a rabbi of a local religious institution. However, it is often the case that there is no single person or group that is responsible for either monitoring the range and quality of community programs for youth or making sure that information about community program is easily accessible to members of the community. So, adolescents and community that are rich development opportunities for them experience reduced risk and show evidence of higher rates of positive development. So, a diversity of program opportunities in each community is more likely to support broad adolescent development and attract the interest of and meet the needs of a greater number of youth. So, the complex characteristics of adolescent development and the increasing diversity of the country make the heterogeneity of young people in communities both a norm and challenge. So, therefore, effective program must be flexible enough to adapt to this existing diversity. So, among the young people they serve in the communities in which they operate, even with the best staff and best funding. So, no single program can serve all young people or incorporate all of the features of positive developmental setting. So, young people who have the most severe unmet needs in their lives are particularly in jeopardy of participating in risk behavior such as dropping out of school, participating in violent behavior, or using drugs and alcohol. And young people with the most severe unmet needs often live in very poor and high-risk neighbor with a few opportunities to get the critical experiences needed for positive development. So, they are often experience repeated racial and ethnic discrimination. Such youth have substantial amount of free and supervised time during their non-school hours. So, other youth who are in special need of more programs include youth with disabilities of all kinds, youth from troubled family situation, and youth with special needs for places to find emotional support. So, to provide for the most appropriate kinds of community programs for the diversity of youth and community. Communities should regularly assess the needs of adolescents and family and review available opportunities of their young people. So while individual communities will invariably answer this challenge differently and make different judgment about the most appropriate ways to meet adolescent and community needs, there are several specific steps that the committee recommends be taken to support this kind of community mapping and monitoring. So, community programs, so this is the recommendation, no? Our recommendation are the community programs for youth should be based on a developmental framework that supports the acquisition of personal and social assets in environmental and through activities that promote both current adolescent well-being and future successful transition to adulthood. So the community should provide an ample array of program opportunities that appeal to and meet the needs of diverse youth and should do so through local entities that can coordinate such work across the entire community. So particular attention should be placed in programs for disadvantaged and underserved youth. So to increase the likelihood that an ample array of program opportunities will be available, communities should put in place some locally appropriate mechanism for monitoring the availability, accessibility, and quality of programs for youth and their community. So, the private and public funders should provide the resources needed at the community level to develop and support community-wide programming that is orderly, coordinated, and evaluated in reasonable ways in addition to support at the community level. So this is likely to involve support intermediary organization and collaborative teams that include researchers, practitioners, funders, and policy makers. So, that's end. I hope na may nakuha po kayong importanteng information. So, thank you po and God bless.